Now that you understand the 4 legal pillars for protecting your intellectual property, the strategies that you can use to protect your intellectual property regardless of which IP to own, let's talk about the IP mistakes to avoid. The essence of talking about these mistakes is to enable you refrain from making any of the mistakes that threaten your ownership or your exclusive rights over the intellectual property. And here are some of the mistakes. Hi, I'm Norma Grace, a corporate and tech lawyer passionate about helping founders like you start, grow, and scale their businesses, their intellectual property, and their technology. And I do all that by protecting your business, your IP, and your technology, and your future. Mistake number 1, not conducting a detailed intellectual property audit of your existing assets. Now, many companies, many individuals, many freelancers, entrepreneurs, whatever, they have these ideas that they have put down, they have penned down, but they don't even know that those are worth protecting. And as a company, that is costing you because you need to first of all conduct an IP audit within your company to understand what are the assets that I have that are worthy of protection. Now, once you figure that out, take adequate steps to protect them. Mistake number 2, publicly disclosing your intellectual property before you have sought its protection. Again, as I've been saying throughout this entire video, publicizing your IP before you protect it or before you apply for its protection can make you ineligible for protection. It can void your protection completely. Mistake number 3, not using adequate IP research or data insights to guide your research and your development efforts. So if you want to develop new intellectual property, not using adequate data to guide what technology you develop, whether or not it's even needed, what inventions you create, and so on and so forth. When you do not use IP research or even data-driven insights to do this, then you risk creating a technology or an intellectual property that is practically worthless. Although no IP is worthless, everything is worth protecting, but still, commercially viable is what I mean. Mistake number 4, not monitoring your competitors' intellectual property and what they are doing with theirs. The reason to do this is not to copy, but to just give you an idea of what your competitors are doing in the market. That way, you're able to either one-up them or you're able to either strategically respond with your marketing efforts. Just to, kind of keep you in the loop and understand what is going on in your industry. Mistake number 5, not periodically conducting an audit or identifying the intellectual property that you have within you, which is like, for instance, your technical know-how, which can serve as trade secrets and other intellectual property that you can easily protect. To identify IP that you are not taking adequate use of, periodically ask yourself, what am I doing better than others in the market? What am I doing differently? Once you're able to answer this, it may point you in the right direction. Mistake number 6, failing to keep adequate records of your intellectual property creation process, whether it's your prototypes or your brainstorming notes or your session notes or whatever kind of record it is. You need to keep adequate records of that process because number 1, it helps with your filing, and number 2, it helps with your corporate memory, so you know the stages that a particular thing went through to be able to track it, make updates, progress, and all that good stuff. Mistake number 7, and I see this one a lot with people that use open source software, is assuming that you own the intellectual property when you built it on top of an existing infrastructure. So let's take, for instance, now you have this open source software that you're able to use and you build your tech product on top or using the open source software as a foundation to your intellectual property, and then assuming that you own the whole thing. You don't. It's not yours. Whether or not you improved it, that does not mean that you own it because you built it on top of someone else's intellectual property. You might own your bit that you added, but you do not own the IP in its entirety because it belonged to someone else and you just built on top of it. So take very close note of that, especially when you're using open source softwares. To go the extra mile, make sure that you are licensed to use that intellectual property. Then and only then can you claim some sort of ownership for your tech product that you built on top of it. Anyways, mistake number 8 is not having an appropriate budget for your IP protection and your portfolio management, or even trying to DIY your IP protection. Now, while again, most of these IPs you can do them by yourself, for instance, copyright, it's always advisable to do them with an expert so that if you run into issues, the expert has already done this many times and he has already anticipated such issues so that you bypass them. But when you do them yourself, you're learning from the very beginning and you're prone to make more mistakes, spend more time, and spend more resources course correcting. And we don't want all that time wastage. So you need to keep an adequate budget for IP protection and portfolio management and engage the services of an expert. Mistake number 9 is not protecting your intellectual property in the right jurisdiction. Now, if you are operating solely in one country, make sure you register your intellectual property in that country. But the moment you decide you want to operate in another country or that you want to scale into another country, make sure that you have adequate IP protection in the other country that you are going to. See this use case now of UGs in Australia and UGs in the US, and how this legal battle that they're having over UGs in Australia and UGs in the US, and yeah, nobody wants legal battles like that. So make sure that if you're going to scale into another country, you have the adequate protections in the other country that you are going to. All these are mistakes that any tech startup or SME or even business alike can take and implement in their own organization to protect their IP for themselves. Now that you understand intellectual property, you understand the mistakes to avoid, you understand the strategies, what are the ways or how can you make money from your intellectual property? Whether or not you have finished building it or you are still building it, how can you make money from it? There are about 3 major ways that you can make money from your intellectual property in whatever stage you have it. And that is either by licensing it, by selling it off outrightly, or by franchising it. When you license your intellectual property, you give others the right to use it. Now that right can be exclusive, meaning that you're giving one person or one entity the right to use your intellectual property. Or it can be non-exclusive, which means you are giving it to a wider range of people to use. A license is basically customizable to whatever you want. So it can be exclusive, it can be non-exclusive, it can be renewable after 1 year, it can be non-renewable, it can be for a fee, it can be for royalties, it can be for any other barter thing you want, or any other type of compensation that you want. Maybe you want it for a fee, maybe you want it for a service. Whatever the case is, it's easily customizable and it's the most popular way of monetizing your intellectual property. Another one is by outrightly selling it. So you have developed this project and you want to outrightly sell it. You need quick cash and you want to let go of it at the moment. So you can easily sell it, right? Someone else or another entity can acquire it and you lose every right to that. People usually sell their intellectual property when they need quick money, when they want like fast cash, it's quite urgent and you want, then you can sell. But licensing is it's a long-term thing, and licensing is oftentimes more advisable than an outright sale of your copyright. If your intellectual property has a successful business model upon which it runs, then you can franchise that business model to any other entity that wants to use it, really. So think of Chicken Republic now, franchising and having so many branches, right? It not necessarily be Chicken Republic that has that many branches. It's just Chicken Republic has the one, and then they've been able to franchise their business model to other entities who are then able to replicate that across board. That's why you think that Chicken Republic has so many branches all over the place. Not necessarily. They might just have the one branch and then franchise their business model out to others. So you can also do that with your intellectual property, provided it has a successful business model upon which it runs. And that kind of gives you a little bit more control over your intellectual property, because then you have defined the standard upon which that intellectual property should be used, and every other franchisee is obligated to follow the standards that you have set out. It's a bit more complicated to run, but it's also a very, very good way of monetizing your intellectual property. Another way that you can monetize your intellectual property is also through investors. Now, any company, any startup that has an intellectual property that is actually worth something huge can attract more investors that way. So very recently, Qualcomm has been in the news. Why? Because it sold for billions of dollars. And why did it do that? It started off as a small company, but it had a patent. It had a patent that was massively successful, and because of that patent that it had, it gave it this valuation that ordinarily Qualcomm as a company would not have had. So you see, investor appeals. Having such an IP protection can vastly increase your company's appeal to investors and also your valuation as a company too. And you find that in whatever way you choose to monetize your intellectual property, whether you want to actively manage it as a business by yourself, or you want to license it, you want to franchise it, you want to sell it, or you want it to have investor appeal. Either way, your intellectual property is protected and it's making money, whether or not you choose to pivot as a person or as a business. It's making money. It's almost like passive income. You've worked for it in advance and now it's making money, generating income for you as the years go by. And it depends on the type of intellectual property that you build. It can actually be more profitable as time goes on. So the profit just increases as time goes on. It ages like fine wine, I would say. That brings us to the end of this video, guys. By now, I am sure that you have a very, very, very strong idea of what intellectual property is, the 4 pillars of intellectual property that you can use to protect your tech product, strategies that you can use regardless of what type of IP that you own, the IP mistakes to avoid, and the ways you can monetize your intellectual property. So what do you have to do? Subscribe, stay updated, and I will see you in my next video. Bye!